Good morning. Happy Saturday. Once again, Blue Bacon is banging on the 18 USC 795 drum. And apparently, I didn't realize this, but apparently I made a mistake when I tried to use sarcasm with Blue Bacon, because he took a video that I titled sarcastically as an apology and didn't watch the video, but just assumed that I actually admitted that I was wrong. And, well, sarcasm is lost on the stupid. Once again, for the slow kids in the classroom, 18 USC 795 is very specific in what it deals with. It deals with, number one, information. How do you know it deals with information? Well, there's a couple hints for you. Number one, it says information several times through it. Whenever the president determines that there's vital or protection against dissemination of vital information, I think is the terminology we're looking for in there. Dissemination of vital information. It doesn't deal with trespass. 18 USC, I'm going to say 1382, deals with trespass on a military base. But 18 USC 795 deals with the dissemination of vital information. It says it in the title, photographing and sketching vital military installations and equipment. The list of things that it prohibits: sketching, graphing, mapping. They all deal with information. A photograph is information. So number one, it deals with information. And number two, the president gets to define. Whenever the president defines certain vital military installations and equipment as being important to the national security interest, whatever it says, don't really care, doesn't matter. The president gets to define it. So those two important things that you need to know to deal with a dumbass like Blue Bacon, who is, I want to remind you, a military policeman, not a lawyer. He has no fucking idea what he's talking about. He thinks I need to present him new facts when we're arguing a point of law. There's a reason why lawyers distinguish between the facts and the law. There's a reason why the jury determines the facts and the judge determines the law. You dumb shit. If you don't understand these basic things, why do you think you're competent to be giving people legal advice like don't film military gates? So now that we've determined we're dealing with information and we're dealing with a president's definition of a vital military installation or equipment, we can begin to examine the statute. Number one, information. The president defines the information that needs protection against dissemination as being designated, marked, or classified top secret, secret, confidential, or back then restricted. That was back then. The president has subsequently eliminated the restricted designation, classification, or marking. So we know it's dealing with information, and in the subsequent executive orders where the president is dealing with information and eliminated the restricted category, that's what the president is talking about. It's information. Again, photographs, dissemination of information. Classifications are for information. It is to protect information. This is not a difficult concept. Restricting access is not the same thing as restricting information. Restricting access means that only specific persons can have access. Restricting information means that if somebody has a photo of that, whatever it is, they can be charged. So, we know it's information. Information has to be top secret, secret, or confidential. Restricted doesn't cut it. Number two, president's definition. The president defined vital military installations in a two-part analysis. Number one, it has to be designated, marked, or classified, top secret, secret, or classified, top secret, secret, or confidential. And number two, it has to be located within, specifically, it says within a post, base, yard, on a military ship, in a in a specific kind of area. I mean, it specifies the areas and zones and places that the vital military installation has to be located within. Now, you have to give meaning to the words in the definition that the president provided. And I don't give two shits if somebody else uses installation in a different way, or if installation is used a different way in a different statute. That doesn't matter, because Congress specifically gave the power to the president to define what these certain vital military installations are, what these certain ones are. Not what generally speaking installations are, but what these certain vital military installations are. And the president has done so, and he's decided they must be located within a base. Now, the president could have just said it has to be a base, but he didn't. He said it has to be located within a base. And you have to give meaning to those words. So saying that the gates or the walls of a base are within the base is meaningless. It doesn't actually give meaning to the word within. And if you're going to construct the statute appropriately, you have to give meaning to all the words. Each word has to have a meaning. You can't assume a word is superfluous just because you don't like it being there. So gates aren't located within. If, for whatever reason, if we took Blue Bacon's reading of the statute to be the gospel truth, then it would certainly fail strict scrutiny, because it would be a strict scrutiny analysis. And in order to pass a strict scrutiny analysis, as we are all aware, number one, it has to be a compelling government interest, not an important government interest, but a compelling government interest. And having a picture get out of your gate or a drawing or a sketch or a map, oh Lord, did you realize that it would be a violation of 18 USC 795 under Blue Bacon's retarded interpretation to have a map of a gate? Well, the weird thing is, and this will blow your mind, but gates are on every fucking Google map. You can figure out where all the gates are on a base by going to Google Maps. So that should tell you that maybe the gates aren't what's restricted, but it has to be a compelling government interest, and not having pictures taken of a gate to a military base is most likely not a compelling government interest. Number two, it has to be the least restrictive, not narrowly tailored, but it has to be the absolutely least restrictive method of achieving that compelling government interest. If the government didn't want you to take a picture of a gate, you know what they should do? They should build a gate in front of it to block you from taking pictures of the gate they don't want you to take a picture of. That, my friends, is what's called a strict scrutiny analysis, which, since this is content-based restrictions, would have to pass a strict scrutiny analysis. It can't pass a strict scrutiny analysis. However, if the government takes those extra steps of making sure the vital military installation is located within a base, behind the walls, behind the gate, behind the guards, then you could say, well, you know what? Having that top secret nuclear lab, or whatever the hell it is, located behind the walls is the least restrictive way. This law is the least restrictive way of achieving our goals, because we already have it behind walls. There's another, like the next 18 USC 790, I'm going to say 7, deals with like flying a plane, going up in a plane to take pictures over the walls of the fort or base or post or arsenal, or whatever the fuck they want to call this particular patch of military ground. Because again, we're dealing with information. We're not dealing with trespassing. We're dealing with information. And information, again, is dealt with on the classified spectrum of confidential, top secret, or secret. So anyway, those are two huge reasons why Blue Bacon's argument is fucking bollocks. Now, for a real world example of why Blue Bacon's analysis is bollocks, we have James fucking Freeman, James Allen Springer, arrested for 18 USC 795. They have his video. He fucking filmed the gate. He filmed it. the buffalo gate or whatever the hell it was. He filmed it. They have the film. They have the film. Open and shut case. But suddenly, for some reason, and you know, this would really make an inquisitive mind start to wonder, start to to themselves. For some reason, when they couldn't get the guard, the MP who arrested Springer, when they couldn't get him, they had to drop the case. Now, why is that, do you think? Why is that? They have the film. I mean, it's evident. James Allen Springer filmed that gate, and they dropped it. Well, they dropped it because they didn't have the guard to say where Freeman's flip-flops were, to say where his feet were, because you can't tell where Freeman's feet were if he wasn't filming his feet. So they were actually angling for that trespass charge they were going to get him on. Because 18 USC 795, once again, requires it to be filming top secret, or confidential information that has to be located within a military base. Anyway, I hope that makes things clear. And you know what? Just to show you how confident I am of my analysis, I'm going to make everybody this offer. If you get arrested for a violation of 18 USC 795, and they're not accusing you of entering onto the base. They're not accusing you of entering on the base, but they are accusing you of violating 18 USC 795 solely for filming the walls or the gate of a military base from off of military base property, that I will defend you free of charge. Free of charge. You would have to pay, I would make you pay my fees, and my fee would be the whatever fee it takes to pro hac vice in whatever district you're being charged in. I think that's like $500 or roughly around there. Anyway, but beyond that, everything else, all my hourly charges, I would waive them because that's how confident I am. And I would challenge Blue Bacon to do the same thing, but he's not a fucking attorney. He's a cop. And magically, he thinks that the simple reading of the statute suffices without taking the time to figure out what restricted is referring to and what is actually being charged. The photography, the information is the issue. It's the information. And so top secret, or class or confidential are the only things that apply. And he thinks installation, I call every military base an installation, but he doesn't stop to think of why the statute calls for the president to define it. For the purposes of that statute, the president has to define it. Anyway, I got to pick up dog poop. Thanks for watching. Have a great day.